So we submit that as far as the choice of law issue is concerned, that no other court would reasonably conclude that a different outcome should be arrived at. And in any event, even if South African law were to apply, the conclusion would be the same. And that is that the Zambian government would have the burial right. And that is the clear right that the applicant, that the respondent relies on in the founding papers. It says, I have a right to bury. And the fact that the late president is in South Africa does not detract from that right. And that right can be enforced in this country. There's nothing sinister about the government turning to the South African courts to enforce a right that it has in terms of Zambian law, and ultimately also in terms of South African law. In the leave to appeal, the applicants raise some 16 grounds. In the heads of argument, we classed it thematically into three categories, or three themes. The first one is the correctness of the judgment as far as FAA 7 is concerned. The applicants contend that was never an agreement. That flies in the face. Respond on the applicant's own version. They agreed to the implementation of FAA 7. Their spokesperson, the seventh respondent, confirmed the agreement. He called it a compromise agreement. And it is that agreement that the court found existed, and it correctly applied the canons of contractual interpretation. The reference is there to Ndumeni. And the second theme, the conflict of law issue, I dealt with. And the third is that the court erred in that when it granted Pref 4, it granted an order for the repatriation, whereas what they said is that in the notice of motion, declaratory relief was sought. And the answer to that criticism is simply the following. The Constitutional Court stated and learned that the order issued was not supported by the facts on the record and the application of the relevant law to them. And what we say is that the relief in Prayer 4 mirrors what is granted in Prayer 5. So Prayer 4 simply says that the government is ordered. I just need to get to that prayer. It is ordered that the applicant is entitled to repatriate the body of the late president for a state funeral and a burial thereafter. And then 5 mirrors that. The 8th respondent is authorized and ordered upon service of the court order by the sheriff to immediately surrender the body of the late president to a representative for repatriation for the purposes in 4. So, under circumstances where Prayer 5 is clearly and demonstrably not at odds with the facts and the law, Prayer 4, that simply mirrors that, also cannot could not have been incompetent, and the court could have granted it. What we say in conclusion is that the application for leave to appeal has no prospects of success, neither in terms of 17(1)(a), Roman 1, or in terms of Roman numeral 2. And the reason why we submit that there are no grounds for concluding that there would be an important question of law, or that the test in terms of Roman sub 2 is met, is because of the uncertainty. What is this discrete issue of public importance that will have an effect on future disputes? What is that issue? Justice Potterell, you asked that question. How would such a dispute that is in the present case so fact-specific again arise in future? How would another court reasonably conclude that that may be the case? What would be the dispute that may arise? I submit that the applicants can't answer this question. So on the second leg of the leave to appeal, we submit that there is also no grounds. This application falls to be dismissed with costs, scale C, inclusive of 2 counsel. Apart from that, we abide by what's in the heads of argument, justices.
Thank you, Christian.
Let me start with where my learned friend started. So my learned friend's premise is the following. One, he accepts that the agreement is to be interpreted or applied according to South African law. But then he says that because what he calls the lex causa is Zambian, therefore the right to bury is Zambian. And then he says that the agreement is not about the corpse, it is about the right to bury. Now that's the basic premise of his argument. On the first argument about the distinction between the lex loci contractu and the lex causa, it's actually not recognized anywhere in the law. If the court looks at paragraph 99 to 101 of 111 rather of the MTN judgment, the word lex causa simply refers to the cause of action, nothing else. What determines which law applies is lex loci. And so it then takes over the entire dispute. And it's obvious why that is so. If you followed my learned friend, you would end up with conflicting outcomes because you will always split out lex causa from lex loci. That's just illogical. So once we've decided the lex loci, then everything that falls under that is then to be decided in accordance with the law of the lex loci. So if my learned friend concedes that the lex loci is South African law, then the dispute is to be decided according to South African law. Zambian law becomes irrelevant. So he has in fact proven the very problem that we've been trying to say in a very inarticulate way. So if he concedes that the lex loci is South African law, the question then is, was South African law correctly applied in denying Ms. Lungu the right to bury the husband? That then has enormous implications for future disputes. Enormous implications about wives unable to make a decision over the body of their husbands. On a supposed public interest, see what they've now started doing? They've now also started referring to the Senyati case, to say even there the public interest was held to override the wishes of the spouse. So we are now right at the commencement of a dangerous road towards the deprivation of the rights of widows to take care of the bones of their spouses. So South African law could never countenance this outcome that we have here. South African law has been clear on the common law perspective and on the constitutional law, that the right of the spouse is basically unqualified. She decides what to do. If she's dead, the children decide what to do, but it's the family that decides. A lot of the cases have tended to be intra-family, like the Sengati case, have tended to be intra-family. But once it's inter-family, it's family versus others. The family trumps. That's the core of the South African law. And then the second aspect, which my learned friend just doesn't address at all, he addresses it by avoidance, is the question of the validity and enforceability of a contract over a dead body. Foot and Grotius are so clear on this. There's no enforceable South African contract over human remains. And those articles we've referred to are clear on the point. Again, if my learned friend is right, we also create new law in which we turn against the common law and we say, from now on, you can contract over human remains. And you can contract against the wishes of the family over human remains. That, again, is not part and parcel of South African law. So, again, those two mistakes that my learned friend has made in his argument simply show why the dispute ought to be decided by the Supreme Court of Appeal. On the Lex Loci, he is dead in the water because South African law applies. Number two, on South African principles, there is an unqualified right of the spouse. And number three, on South African principles, there is a proscription, a prohibition on contracting over human remains. Then the dispute becomes a narrower dispute than the one we outlined. But it becomes an incredibly important dispute because it sets out binding precedent for the future. My learned friend also says he cannot see what this important issue of law that will live beyond this judgment. He may not see it, but we see it. The important issue of law is the contest between the rights of a state as well as the rights of the family to decide on the burial. He himself has pointed out to a case in South Africa where this issue arose. A provincial government decides to take over the body of a deceased husband and says, I'm going to bury this body. The spouse says, I don't want to. I want to bury this body according to what I want and what he wanted before he died. According to him, the wishes of that spouse must be overridden by the wishes of the government. This is so foundational to the right to bodily integrity and autonomy in South Africa that it simply can never be the South African legal precedent. So I'm afraid if he did not see the important point of law, he has himself inadvertently articulated the problem that we say deserves the attention of the Supreme Court of Appeal.
Sorry, can I ask you, what does this judgment, what is the binding principle of this judgment?
Well, there are two as we understand it. The first principle is that the interests of a spouse can be overridden by
a foreign government.
By a government. In this case, it happens to be a foreign government, but by a government. Now, that we say is a fundamental problem. The second one is that a contract, my learned friend characterizes differently, over a dead body or over a corpse, is a recognized species of contract in South African law. Now, those two principles, outside of the issue of prospects of success, those two issues are legal principles that will forever be relied upon. And you know, one of the reasons, Justice Libraga, is that they will say this was a full court decision and it has an elevated status for future disputes. And they can ignore Justice Mokgoatleng's judgment as a single judge who decided a fact-specific case. But they can't ignore this judgment because this is a judgment given by 3 judges of the Pretoria High Court. And so those principles will remain with us, whatever happens. And that's why we ask that you kindly refer the matter for determination in the Supreme Court of Appeal. Thank you, Justices.
Costs?
Well, if I win, there are no costs because there will be costs in the appeal.
Yes. And if you lose?
Well, this is a private dispute. So I think I got costs against me anyway in the... I didn't. Oh, no, then I should not get costs. You know, you should always have a junior. Then there should be no costs, regardless of the outcome.
Thank you.
Perhaps in your paper earlier on, I alluded to the following, that the extra articles that you handed up should be given on the case lines to the credit of your instructing lawyers and junior. These articles are there on case lines.
Oh, thank you. Again, it's my own ignorance. It's so clear who's running the case.
Unless you need them for other references, I have them online.
Yes, I probably should. I don't know. Maybe as Justice Potter says, I'll never get a burial dispute again. Then take them. I have nothing else to say.
Thank you very much. Judgment is reserved for the judge.